The fallout of Justice Alito's abortion draft leak has many questioning what other rights might be upended if the High Court does indeed overturn Roe v. Wade. As USA Today notes, the legal principles that the Supreme Court said in 1973 are the basis for the right to abortion are the same ones it relied on to recognize other rights not explicitly noted in the Constitution.
While we won't know the court's official ruling in another month or so, here to break down what this all might mean is public defender and commentator Olayemi Olurin. Welcome back.
Thank you. Thank you for having me.
Yeah, great to have you. So Olayemi, where do you weigh in on all this? What other rights are you concerned or that might be threatened under a regime where there's no more Roe and the issues are turned back to the states?
A significant amount of rights are actually threatened by this because, as Alito put it, the right to an abortion is not explicitly mentioned in the Constitution or, as he says, rooted in our nation's history, which a lot of the rights that we depend on are. So, it's funny because people have long been worried of what a conservative majority on the Supreme Court would mean for our rights and our civil liberties. And here comes this sweeping opinion. And, should this be the law? Should this opinion go the way that we've read it, right? And I think the issue with it from the beginning starts with Alito presents the right to abortion as a mere intellectual exercise, as a disagreement among three different groups that he has to decide in favor of the school of thought he prefers rather than a real issue that impacts real people. He positions himself as a sort of champion of states' rights. The argument he makes is prior to deciding Roe versus Wade, the states were free to make the decisions for abortions. And by deciding Roe versus Wade, we've somehow robbed the states of their free will. So to that, I would ask, what about the free will of actual human beings who've exercised this right to choose whether or not they want an abortion for the last almost 50 years? Where is the free will in forcing women to go through pregnancies, motherhood, all of the complications, risks, and associated costs that the state will not deal with or help them with? He says that we should overturn Roe in order to let states step in. And I think he puts do as their citizens wish. But this has nothing to do with what citizens wish or free will, because as it currently stands, people have this constitutional right to choose whether or not they want an abortion. Roe versus Wade does not force people to have an abortion. It doesn't force a decision on them. What it does is prevent the state from forcing its will onto people. So he compares the decision to Plessy versus Ferguson, which is an absurd comparison, but he makes it because he says both decisions were egregiously wrong from the jump. We shouldn't even really humor this comparison, but I want to say this. While Plessy versus Ferguson confers a badge of inferiority amongst an entire group of people, Roe versus Wade does not do that. And so this is an issue. This is going to be a major issue because so many of our rights, the right to contraception, the right to choose an education, so many rights have been based in this exact same framework of substantive due process. And so we should be concerned. But I would say this. In the same way that he says that there's no explicit mention to the right to an abortion in the Constitution, there's also no explicit mention to 9 justices serving on the Supreme Court. So I think now we need to start having a conversation about how we circumvent the consequences of this.
Yeah, Olayemi, I think that's a good point that I brought up in my radar, that so much of what we think of as kind of the norms in terms of constitutional practice are either recent inventions or were in no way indicated by the Constitution in the first place. The right of the court to even do judicial review comes from Marbury v. Madison. It was a judicial fiat in and of itself, and people are questioning about whether or not we need more substantive reform. This case is interesting because Roe is one of the few instances where the judicial activism has swung in the direction of what we consider to be progressive interest in protecting, broader, historically persecuted minorities. But isn't the problem here fundamentally that legislators haven't actually codified any of this in law? Should we be relying on an institution like the Supreme Court, which is kind of fundamentally by its design regressive, always looking back to see what the founding fathers say? Fundamentally originalism, textualism is all about trying to find some contemporary issue, an answer to a contemporary issue in a document that was written 200 years ago. Should we be even playing these games with the Supreme Court and relying on it in the way that the left has been doing?
No, I absolutely don't think we should. We shouldn't be, heralding the Supreme Court as some kind of champion of civil liberties at all. And I think there's a dangerous game with originalism and framers' intent. When Alito and people in general, when they discuss what the framers intended or what's rooted in our nation's history, we have to remember that the framers never intended a significant amount of groups and a significant part of our population to have any of these rights or protections. So it's dangerous to say, hey, we've relied on these rights for 50 years and, the majority of the country might support it, which they do. The majority of the country country does support the right to abortion and different protections that we have that are going to come, that have come in the form of substantive due processes cases, saying, oh, it's not rooted in our nation's history, so we're going to get rid of this right. What does that mean for the rest of us? It's a very, very dangerous game. So no, we should not be relying on the court.
Well, I guess I would say, to play devil's advocate, right, a majority of the country thinks that abortion should be legal in many circumstances, but that there should be some restrictions in some circumstances. And in a absent Roe, that question is now put back to legislatures to enact the will of the people. In some sense, this is getting rid of the decision or reversing the decision. Adds more democratic accountability or democratic governance to the process of deciding what is the right level of abortion to permit in the country or in the states. So I guess that would be my counter to this perspective you're offering.
But isn't the will of the people exercised in choice, right? If we're concerned about people getting rid, if we're concerned about people being able to do what they want, or what reflects the majority of the population, or what people would like to see, as it currently stands, if we have the right to abortion, every individual is free to decide whether or not they want to engage in it at all, right? So getting rid of the right to abortion only opens us up to more states regulating it or completely banning it. That's what's going to happen in some places, not this situation where we just get a little bit more regulation. That's not what's going to happen. People.
Yeah, I mean, sure, right. I mean, that's what governments do. They put limits on people's rights. They put lots of limits on lots of rights. I don't think should be put on.
But the whole point of the Bill of Rights is that it protects the people against those kind of offensive rights. So the freedom of speech.
This isn't one of them. It's not written in there. Right. It's not one of them.
The freedom of speech.
You know how many rights aren't listed in the in the Constitution?
That's why we have the Ninth Amendment. The Ninth Amendment says this list is not total.
Right.
It's saying everything. Other things might come up, and so that's why we have these substantive due process rights that are read through the 14th Amendment. And that has been the basis of a whole number of protections that didn't exist back when the founding fathers were doing their thing, because, they were busy owning slaves, the Bill of Rights and not understanding what penicillin was.
It's a baseline, and there are more things, but you can't, if it's just not in there, it's not in there. That's not saying it shouldn't be a right, but it's not in there.
So here's the question, Ola. So go ahead, Kim.
No, you go ahead. You go. You guys finish this one up. This part of the conversation.
I do think this is the point. We're always going to be having this argument about what the Constitution says and what the founding fathers meant, as long as we're still reliant on the Constitution. So I do have some empathy for an argument that was made, by Glenn Greenwald a couple of days ago, that basically said, hey, this is the purpose of the Constitution. It was supposed to be this check on power. It is anti-majoritarian. It's not about the freedom's will. And I say, okay, fine. When are we then going to have a more substantive conversation about why the Democrats have not legislated abortion law if it's been around since the 1970s? Why are we trying to find a substantive, privacy right? I'm glad those cases came out the way they did. I'm glad gay people can get married. I'm glad, gay sex isn't illegal. But why are we relying on reading between the lines of a bunch of people who never contemplated such a thing as gay marriage to establish these fundamental rights, instead of having a system that's flexible enough for our democratic will to result in laws and even substantive changes to the Constitution?
Or better yet, I think when we talk about framers' intent and originalism and what is rooted in our nation's history, why don't we have the honest conversation that our framers did not intend for the protections and rights that we now afford? The current civil society that we live in was not intended by our framers. Me and Briahna sitting up here talking to y'all was not intended by our framers. So it's a very dangerous game where we pretend. Kim either, right? Only Robby's supposed to be up here talking according to the framers.
I'm sure I would have been dragged through the streets for some kind of heretical opinion I had. It's not. The pitchforks would have come for Robby. Let's all be clear.
I'm sure they would have got you eventually, Robby, but they would have got the rest of us out of here from the jump. And that is the point. We can't just say in the year 2022, rights that we have had that reflect the current civil society that we live in should go away because the framers didn't intend them, or they're not rooted in our nation's history. And a dangerous game he does is he says, because the right to abortion had been previously criminalized, that's grounds to get rid of the right now. Do you know how many things have been previously criminalized? How many? Yeah, we're in a very, very dangerous game. If we go by the argument that if it's not rooted in our nation's history, if we have a previous history of criminalizing it, then that shouldn't be a right, and we should let the states do whatever. dangerous game. It means a dangerous game, just not just for people relying on the right to abortion, but any marginalized group that need these protections. And that's why this is scary. You know, people have been called alarmists for being very, very concerned about this conservative majority, but we see that come into fruition.
Olayemi, I wanted to ask you before we wrap, what you make of people like Jeanine Pirro who are calling for the incarceration of whoever it was that leaked this opinion.
Child, first of all, who cares? In my personal opinion, I don't care who leaked it at all, but I think that's ridiculous. I've seen that argument. I think it was Roberts talking about how this challenges the integrity of the court, the fact that this opinion was leaked. I think the contents of the opinion is what challenges the integrity of the court, and I rather focus on that.
Yeah. I don't think the person should be prosecuted. I don't know what you'd even prosecute them for.
Who
they
did
should
it?
probably lose their job and then go on to be a hero to progressives forever. Do it and be legends kind of thing.
Yeah.
Olayemi, thank you so much for joining us. Tomorrow on Rising, writer Matt Stoller details how a Time Warner merger led to censorship.
And we'll continue covering the SCOTUS memo leak as well as the big news of the day.
Be sure to like, share, and subscribe so you never miss an episode. And be sure to follow us wherever you follow your podcasts. Download us so that you can listen to us on the go. Thanks so much for watching, guys. We will see you tomorrow.